Welcome back to Counting to Five, a podcast about the United States Supreme Court. In this episode, I'm going to preview 11 newly granted Supreme Court cases that will likely be argued in April. The remainder of this podcast episode consists of audio from a Counting to Five YouTube live stream, which aired on Thursday, January 18th. Please stick around at the end of the episode for more about upcoming live streams. And now, the January 18th live stream. Hi, I'm Mike. I'm the host of the Counting to Five Supreme Court podcast, and this is our weekly YouTube live stream. We are currently broadcasting these every Thursday at 9 p.m. Eastern Time to talk about the latest developments at the Supreme Court. And if you are watching this live, you can please feel free to ask your questions in the YouTube live chat at any time. And as I go along, I'll try and keep an eye on that and answer some questions as they come up. Today, I'm going to, most of this episode is going to be focused on a bunch of new cases that the court just granted that will likely be argued in April this term. But first, I'm just going to touch real quickly on what else is new at the court and kind of what's the status of the term so far. If you've watched the last couple weeks live streams, one topic that I've been talking about is the lack of opinions from the court this term. We're in January, middle of January, and the court has only issued one single opinion in an argued case so far this term, which is very low. Usually they've had at least a half dozen or so by this point in the year. There's only one by the end of December, which was surprisingly low. We were expecting to get an opinion pretty quick right when the first week of January arguments rolled around, and then this week was the second week of January arguments. And again, there was a lot of anticipation that we'd at least start seeing some opinions roll around, but still no new opinions. This is a record in at least more than 150 years. The court has never been this slow in issuing its opinions. They got to start coming sometime. There's one more opinion likely day when opinions would come out Monday, this coming week, January 22nd. The court will be issuing orders, and maybe there may be some opinions coming with that. But if we don't see opinions then, the next time the court is off for a few weeks before their February session, and the next likely time we would see opinions would not be until February 20th. So hopefully we'll start to see some opinions next week. Give us a little something to dig into while we wait for the February arguments to roll around. What the court has done, though, is grant some more cases to flesh out its term a little bit. I had mentioned before that so far they only had a total of 52 cases on their docket so far, which is very light. And basically, at this point in the term, the only argument session that's left to be filled up with new cases is the April argument session, which is their last arguments of the term. And January is pretty much the last time they can add new cases and fit them onto the April calendar in order to leave time for the briefing schedule so the parties can file their legal briefs between when the case is granted and when the case is argued. And the court did grant a bunch of new cases on Friday, January 12th. The court granted 11 new cases. And it's a good assumption that these are probably intended to fill out the April argument calendar. That would give the court 63 cases for the term, which is low, but in line with a few recent years that have been in that same ballpark, but still a small caseload for the year. So 11 new cases. From this point out, any new cases granted will most likely be slated for the following term. They'll roll around and be argued in October when the court's next term starts. There's always could be exceptions. One big, or I guess two big possible exceptions that are floating out around there are two big litigation that involves controversial policies of the Trump administration. There's the travel ban litigation, and also the DACA litigation. That's the Deferred Action for Childhood Arrivals litigation. And both of these cases have been there have been orders in lower courts issued against the administration, and possibilities of the administration getting a quick appeal up to the Supreme Court, and the court might expedite those cases and get them onto the docket this year. So those are ones to look out for as additional cases that just might make their way onto this year's calendar. But for the most part, from this point on, any new cases the court adds will go to next year's calendar. And it's also possible that of the 11 cases that the court just granted, while they could make it onto the April calendar, it's possible that the court might push one or more of those and let it wait until next October and not put all 11 of them. We won't know for a while yet. The court issues its monthly argument calendars periodically as the year goes on. So far, we have the calendars through February, but haven't seen the March or April calendars. So we won't know for at least another month or more, probably what's going to end up on the April calendar. In just a minute, I'm going to start digging into those 11 cases a little bit and talk about what we can expect later this term. Also this week, the court heard oral arguments on Wednesday and Thursday. Tuesday and Wednesday. Monday was the Martin Luther King holiday, and on Tuesday and Wednesday they heard 2 cases each day. We discussed those 4 cases in last week's live stream. So if you're interested in learning more about those cases that were just argued, you can watch the archived recording from last week. Oral arguments, there was nothing particularly surprising came out at the oral arguments this week. So at this point, we're just waiting on the opinions, which, as in all the cases, we expect opinions for every case by the end of June, the end of the term, when the court goes on its summer recess. So sometime between now and then, we should see opinions start rolling out in all of these cases. And Friday, tomorrow, that's January 19th in the afternoon, the audio for this week's oral arguments will be available on the Supreme Court's website. So if you're interested in any of those last week's cases, you can listen to the argument starting Friday when those come out. So without further ado, let's dive into the cases. There's a lot of these. I'm just going to kind of briefly touch on each of these cases. There's 11 of them, and try and just kind of summarize briefly what's going on, what's the legal issue. There's right now, we have the cert petitions. That's the formal petitions that are filed with the court to ask the court to review the ask the court to take the case, and then the responses, and sometimes there's amicus briefs filed at the cert stage, so briefs filed by parties urging the court to take a particular case, and so we can kind of get a sense from those briefs what the case is about, but we'll get to know a lot more about these cases between now and argument as the merits briefs gets filed. Those are the briefs of the parties now that the case has been accepted, the briefs arguing why one side or the other should win in these cases, and those will start rolling in the next few months for these cases. But I'll run through and just give a brief summary of what we have for each of these cases. If you see news coverage of this, sometimes it'll be reported as 12 new cases granted, sometimes 11. The reason for the differences in numbers is that sometimes when the court grants multiple cases on the same or a very closely related legal issue, it will consolidate those cases into a single case for purposes of argument and usually for briefing as well. And so when I say 11 cases, that's because 2 of the cases have been consolidated. They'll be argued together in a single hour of oral argument. I feel it's usually clearer and more consistent to just refer to the number of to treat consolidated cases as a single case when we're talking about counting numbers and things, because it's only a single hour of oral argument and typically only one single opinion that resolves any consolidated cases. but sometimes you'll see it reported separately, and either is valid as long as you're kind of clear what the numbers mean. So let's start with those two consolidated cases. These cases are both go by the same name. That's a little less typical. They're both called Abbott versus Perez, Abbott v. Perez. And these two cases are both cases challenging Texas electoral maps. One of the cases is challenging the federal congressional districts, the map for the federal congressional districts in Texas, and the other is challenging the Texas state house district map. And the maps, each of the maps has its own distinct. There's distinct challenges to particular districts, but the overall history of these two maps is basically the same, and there's a big overarching issue that's the same for both. So I'll just kind of give a really brief history. So what happened is in 2011, Texas enacted new electoral maps following the 2010 census, and states have to do this every 10 years after a census. They're required to draw new districts because there's always population movement that requires reapportionment, and in congressional districts, sometimes states will gain or lose electoral districts, so they have to reshape their map based on a greater or smaller number of Congress people. But even for their state legislature, they need to as population shifts around between districts, they need to adjust the lines to keep the districts equally sized in terms of population, and this is done every 10 years after the census. So Texas enacted these new maps, and they were challenged very quickly. They were embroiled in litigation, and there were various allegations against different districts alleging racial gerrymandering, among other things, saying that certain districts had been carved up using race as a criteria in an impermissible way. And it was basically embroiled in litigation. But the 2012 elections were approaching, and there needed to be some resolution for the election. So with the litigation ongoing, the district court that was overseeing this litigation drew up interim maps for the 2012 election for both the congressional districts and the state house districts. So this was a court-drawn map that was drawn to basically avoid some of the challenge districts that were being litigated, to kind of cure the problems that were alleged in those challenges, and these interim maps were put in place, and that was the maps under which the 2012 election was conducted. Now, in 2013, the legislature, with the litigation was still ongoing after the election was over. The 2011 maps that the legislature had enacted were still under this legal challenge that was moving forward. But in 2013, the legislature chose to adopt the court interim plan that had been run for the 2012 election, adopt that as the official electoral maps going forward. So the maps the court had drawn in order to have something in place for the 2012 election became the official maps adopted by the legislature in 2013. Now, this didn't put an end to the litigation. The litigation continued and persisted, and eventually in 2017, so just last year, the district court held that the 2012 plan, the district court held that the 2012 plan, that's the plan that the court had originally drawn up, but the court held that plan and the adoption of that plan in 2013 was tainted by impermissible racial motives of the legislature, and thus there was some impermissible, some discriminatory line drawing in districts, and so that's the issue that's been brought to the Supreme Court. Now, there are specific districts that are being challenged. There's two districts in the federal congressional districts. The one's being challenged for vote dilution. That's where a minority group the allegation is a minority group has been deliberately split up among multiple districts in order to reduce their voting strength. And another district is challenged as a racial gerrymander, meaning that minorities have been packed into a district in order to reduce their influence elsewhere. And there's also a allegation of a racially gerrymandered district in the state state house electoral map. But the big question that's common to both of these maps, and given that the court consolidated these for a single argument, seems like it's a kind of big question that the court may be interested in answering, is to what extent this theory of racial motives by the legislature, whether that can hold up when the legislature was enacting a plan that was actually drawn up by the courts. So the question is, the state argues that, look, we're just adopting what the court did. The court drew up this map specifically to avoid these challenged, districts with challenges about racial gerrymandering and impermissible uses of race. And the district drew up this was supposed to be a fair district and went through an analysis of why this was a legitimate and fair map when it put this interim plan into place. So doesn't that cure any issues any motives that the legislature had in 2011 when it drew up its original map? Aren't they kind of cured by the district court going through and kind of replacing that with its own version of the map? And how can they come back now and say that these racial motives tainted the map when this is a map that the court had drew up and approved? On the other hand, the challengers say, well, the problems we're complaining of here are things that persisted from the original 2011 plan that the district court didn't change when it drew up the 2012 map. And so if there any taint or impermissible motive in 2011 still exists, and just the fact that the district court worked made modifications in other ways to the map doesn't cure those original problems. So that's kind of a big issue that the court's going to have to grapple with there, and depending on how they resolve that question may answer whether they have to kind of get down into the details of the specific districts and exactly what is to what degree the individual districts are impermissible or are okay. Let's move on. The next case is one called Western Gecko v. Ion Geophysical Corp. I don't know if I'm pronouncing that name Western Gecko or Gecko or who knows. I did some real quick internet searching earlier today to try and figure out the pronunciation of that, but came up with nothing very definitive. So we'll wait and see on that. But it's a patent case, and this is a case about the extraterritorial effect of patents, and specifically the calculation of damages. So here's what it's about. Western Gecko has patents on technology to map the ocean floor. And this is used primarily for oil and gas exploration. So they have some type of detectors that get dragged behind boats across the ocean surface, and they map basically the ocean floor. And this is useful to geologists who are trying to figure out where to drill. And this Western Gecko, they didn't sell or license this technology. They just used it themselves to perform these surveys. So this other company, in the case, this Ion Geophysical, they're a U.S. company, and they created a imitation system that, had they assembled and created the system in the United States, it would be infringing of the Western Gecko patents. Now, important thing about patents is patents are territorial. United States patents are valid in the United States, but they, for the most part, don't provide protection against a infringement of the patent or something practicing what the patent protects when it's outside of the United States in some other jurisdiction. However, there's a rule in the patent statute that to prevent people from just evading the coverage of the patent, you can't create the components of an invention covered by a patent in the United States and then ship those components out of the United States to be assembled out of the United States. Even if creating the patent from scratch out of the United States would be fine, because it wouldn't infringe because it's out of the jurisdiction, you can't create those parts here in the U.S. and then just ship them abroad to be assembled abroad. That's kind of an invasion. You wouldn't be able to create the product here and then ship it out, so you can't create the parts of it, ship those out to have them assembled elsewhere. Now that's what this Ion Geophysical was accused of doing. They're accused of creating the components for this ocean mapping technology in Louisiana and then shipping them abroad where they were assembled to become a system that practiced the Western Gecko patent technology. And so the dispute here is not about whether they can be liable for that patent infringement, but the question is what kind of damages are they entitled to? So the patent statute says that when someone is infringing on a patent, the patent owner is entitled to damages adequate to compensate for the infringement. And usually, if this was an entirely domestic context, they'd be able to get lost profits from the infringement. So you'd be able to just basically get the profits that the competitor that was infringing, the profits that they received on their sale of the infringing product, and the patent owner would be able to claim those as its, lost profits that it would have earned. And the question in this case is whether that also applies to these foreign profits from the assembly of components that were produced in the United States and shipped out to be assembled elsewhere. Even though the use of that patented technology outside of the United States by itself would not have been infringing, the fact that use came from the combination of components shipped in violation of the patent out of the U.S. So the argument is that those profits, because they're caused by the infringement, which was the sending the components out of the U.S., then those profits are still kind of traceable to that, and Western Gecko should be able to recover those profits. The argument on the other side is that there's a general principle in most areas of the law that there's a principle that most statutes are presumed to not have extraterritorial application unless Congress has basically made clear otherwise. When a statute provides for liability for something or other, it's assumed to only apply inside the United States. So the argument on the other side is that, given that they specifically have this liability for this conduct that kind of crosses national boundaries, the damages should follow along with that. So we'll see what the court does with that, but they'll clear up kind of the geographic scope of the patent damages in that particular situation. So the next case on the list, the next case on the granted cases is a bankruptcy case. This is a case called Lamar, Archer, and Coffrin v. Appling. And it's a strange little case. It's a question about a provision of bankruptcy law so there's a provision of bankruptcy law that prohibits the discharge of fraudulent debts. So the general purpose of bankruptcy is to give someone a clean start by basically they disclose all of the outstanding debts they have, and then to some extent or another, those debts may be paid off either in part or in whole, or in some cases not at all. And then those debts are discharged and the person has a clean slate to start over. But there's a exception for fraudulent debts. So if someone commits fraud and incurs a debt in committing the fraud, they can't use bankruptcy to clear that away. They remain liable for that fraudulent debt. However, there is an exception when that fraud was due to the financial state of the debtor. So if the debtor basically deceives someone about their own financial state, and that's the fraud involved in allowing them to get the loan, then that can still be discharged. The creditor may be able to avoid that discharge of that debt, but they have to jump through more hoops, and there's more requirements of proof in order for them to do that. So it puts it kind of in a different category. So this was a case. It was a case where a law firm was retained in order to for some litigation over a business. There's some dispute with the previous owners of a business that was owned by Appling, who's one of the parties here. This Appling, who had retained the law firm, fell behind on the monthly payments to the law firm and was in debt a considerable amount of money was owed to the firm. In a meeting with the law firm, he claimed that he was expecting a tax refund of around $100,000 due to an amended filing that he was in the process of making, and basically said that $100,000 that he'd get from the tax refund was earmarked to pay these legal fees. And then he kind of strung the firm along a while when the money wasn't coming through. Eventually, the firm learned that his tax refund was only about $60,000, not the $100,000 that he had claimed it was. And what's more, he spent that $60,000 when he received it on other business expenses. It did not go to the lawyers. So they sued him. He ended up filing for bankruptcy. So the law firm was trying to get their money from him in bankruptcy. Now, they are arguing that his false claims about his expected tax refund let me back up. He is claiming that any false claims about the expected money from the tax refund is a false claim about his financial state, and therefore it is still dischargeable in bankruptcy, and he won't retain the liability for that debt. They're arguing, on the other hand, that no, this is a lie about one particular asset, the tax refund. He made a lie about that. He wasn't making claims about his financial state as a whole, just about this one particular aspect. So I guess the question there is when is a lie about one particular aspect of someone's financial situation, what particular asset or particular liability, when is that a statement about their financial state that is sufficient to bring this into that exception? So that's the question there. The next case on the list is a antitrust case. This one is called Animal Science Products versus Hebei Welcome. And it's a case about, it's a claim against Chinese vitamin manufacturers. There's a claim by some American distributors of vitamins that are produced in Chinese factories that these Chinese manufacturers and distributors were engaged in a price-fixing conspiracy to set the price of these vitamins. Now, their defense, these Chinese companies, is that the price fixing, not that it didn't happen, but that the price fixing was actually required by Chinese law, so that they were that this was not some sort of illicit conspiracy on their part, but they were just following Chinese law as to exports and were required to engage in this price fixing. Now, where this case, the issue that's coming to the court comes in is in the lower court litigation, the Chinese government, in the form of its Ministry of Commerce, appeared as an amicus in the litigation. So basically filed briefs as a friend of the court in the litigation about Chinese law and sided with the companies, saying that yes, those companies were required to engage in this price fixing in order to comply with Chinese law. Now, the district court looked at that evidence, considered what the Chinese government from the Ministry of Commerce had said, but decided, based on the totality of the evidence, based on other evidence about contemporaneous communications with the companies, that was not correct, and decided that the Chinese law did not actually require them to collude on the price as they claimed. This district court was then overruled by the Court of Appeals, which said that when a foreign government appears in litigation, when it's some body from a foreign government that actually has authority to interpret the laws in question, the court must defer to that foreign government's explanation of what its law means. So they said the district court was bound by what the Ministry of Commerce said was Chinese law at the time, and had no authority to disagree with that. And so that's the question coming up to the court. Is that the case? If a foreign country comes into the U.S. court as an amicus and explains what they say their foreign law is, does a U.S. court required to follow that rule. Now, there's some good arguments for it. You'd expect that foreign body would have the expertise. They understand the full legal context, the language, the interpretive practices. They should be very familiar with the laws that were in effect at a given time. There's also, kind of international respect here, a comedy that's it may seem somewhat disrespectful for a U.S. court to be telling the foreign government and coming into court, we don't believe you about what you're saying about your own law. On the other hand, foreign governments may very well have ulterior motives. Here, the Chinese Ministry of Commerce may have an incentive to protect Chinese companies from liability to American companies, even if in doing so they're not being totally upfront about what Chinese law does or does not require. The United States has come in as an amicus in this case and argued that while the foreign government in that position is entitled to a great deal of deference and should be taken seriously, it's not conclusive, and a court is entitled to look at other evidence and go in a different direction if it seems appropriate. So we'll see where the court comes down on that. The next case is a criminal case. It's called Lagos v. United States, and it deals with a statute called the Mandatory Victims Restitution Act. And this is a statute that requires for certain crimes, it requires the convicted defendant to pay restitution to the victims of the crime for certain categories of damage. Now, one of those categories is I'll quote from the statute, it's loss to income and necessary child care, transportation, and other expenses incurred during participation in the investigation or prosecution of the offense or attendance at proceedings related to the offense. The specific crime in this case was a wire fraud conviction, and it was a wire fraud conviction for deceiving the General Electric Capital Corporation, as GECC, about someone's business income in order to obtain loans from GECC. Once the fraud came out, GECC spent money and resources investigating the fraud to kind of get to the bottom of what had happened. They also spent money participating in bankruptcy proceedings after the businesses involved in this fraud declared bankruptcy, and they sought under this Mandatory Victims Restitution Act to recover both the money they spent investigating the fraud and money that they spent participating in the bankruptcy proceeding. And the argument here is that those actions were not. The argument is that provision of the Restitution Act, the Mandatory Victims Restitution Act, is about the participation in a government investigation and prosecution, and it doesn't really apply to internal investigations of a company unless those investigations are somehow required by the government in order to assist its prosecution or the government's investigation. And so the argument is basically that these types of damages don't really fit within that particular category of required compensation. And some of the lower courts have held that, in fact, that provision should be read extremely broadly, so that various, lots of different types of damages can be brought in under that Restitution Act. So the court is going to have to decide what's the best way to read that particular interpretation. So the next case, this is one that's been getting a lot of attention in legal circles. It's called Lucia v. SEC, and it's a constitutional challenge that may have broad implications potentially to other agencies outside the SEC. But what it's basically about is it's a challenge to the SEC's administrative law judges, also called ALJs. And what administrative law judges are is the ALJs, they're like judges, but rather than being members of the judicial branch, so rather than sitting on a court overseen by higher courts in a judicial branch, they're part of an agency. So these ALJs work for the SEC, and they're formally agency officers that sit below the actual commission. The Securities and Exchange Commission supervises their work and can actually appeals from their decisions can be taken up to the SEC, the commission itself. So they're really an executive branch administrative body, but they function much like judges. They hold hearings and proceedings that are very trial-like, and they take evidence and hear witnesses just like a judicial judge would, but they're executive officials. Now, the question here is, what type of officials are they? The SEC considers them to be employees, and the argument here is they're actually federal officers. Now, why does this matter? The reason it matters is the Constitution establishes methods of appointing officers of the United States. So if someone's an officer of the United States, they need to be appointed by the constitutionally prescribed means. And there's different ones depending on whether someone's a principal officer. That's like, that would include, for example, a Supreme Court justice, or, for example, a cabinet level official. Those would clearly be principal officers. But inferior officers have a different process. They can be appointed by the heads of their departments. Employees are a different category. Those are people that are kind of lower down the chain and don't exercise the same level of authority, and they can be hired just through normal hiring processes. There'll just be agency hiring processes. There may be civil service laws that govern the hiring process, but they're not covered by these constitutional rules about how they can be appointed. So the issue is that the SEC ALJs are not appointed by the commission itself, which is what would have to happen if they were inferior officers under their constitution. But instead, that task has been delegated to SEC staff. And so SEC staff, they select these people to be ALJs and put them in those positions. So the particular case that's at the Supreme Court, Lucia, the petitioner in this case, was an investment professional who was charged by the SEC with fraud in some presentations to potential clients. He was tried before an SEC ALJ. He was found guilty, and he was had pretty severe consequences. He was stripped of his license, barred from the industry, and fined. He has brought this challenge, saying that basically the entire proceeding is unconstitutional because the ALJ that position is a officer of the United States, but the person holding that position was not appointed as required by the Constitution, and thus the whole thing was invalid. So that's the question the court's going to have to grapple with here. An interesting twist on this case is that there have been, I guess, two big developments since the case kind of was began in the lower courts. Which one is that there was a change of position in this case under the Trump administration, and where the previous administration had sided with the SEC, the Trump administration has changed the government's position and now agrees with Lucia that these ALJs are officers of the United States and need to be appointed as such. Presumably now that both sides of this case, the federal government and the Lucia, the investment professional who was challenging this, since they both agree and are on taking the same legal position, the court will presumably appoint an amicus, an outside person, to defend the other side of the argument, so they can actually have a adversarial presentation at the court and hear both sides of the issue. So we're assuming that's probably what'll happen in this case. The other interesting issue is that the SEC, in order to try and cure this problem, they took an action the commission ratified the previous appointment of the ALJs by the SEC staff. So they stepped in and said, although they did not originally appoint these people, the staff did, the SEC stepped in and said, we basically ratify that previous appointment. So the question is, does that cure this problem going forward? The Lucia says, well, this doesn't provide any redress to him. He doesn't have any ability. He doesn't get a new hearing. He doesn't have any new opportunity to try to have his case heard under a properly appointed ALJ. But there's also no argument that this doesn't really actually cure the problem for anyone, because these people still weren't appointed by the SEC as they're required to be. It was just ratifying an appointment by some other person who had no authority to appoint in the first place. So that's kind of a issue that's involved in the case. Even if the appointments were not proper, did the SEC cure it in some way by going back and ratifying what had been done? A couple more cases, so I'll just run through these quickly. One of them is Washington v. the United States. And this is a dispute about a series of treaties that the United States made with various Pacific Northwest Indian tribes that guaranteed those tribes access to fishing rights, and specifically to salmon runs in the rivers and streams of Washington State, among other places. And this particular lawsuit's about Washington State, but there are similar treaties in effect in a few other Northwest states. And the issue here is that in lower court litigation, a district court, and this was later upheld or affirmed by the Ninth Circuit Court of Appeals, held that Washington State, under this treaty, had an obligation to make certain changes. Specifically, they need to replace the culverts under state roads in Washington. The culverts that allow water to pass under those roads need to be replaced to also allow fish to pass through. And this is a change. It involves hundreds of culverts throughout an area of the state, and supposedly this amounts to billions of dollars in costs overall to replace these with these special, large flowing culverts that allow the fish to freely swim through. And the issue is, Washington's claim is that the treaties don't impose any such obligation, that the treaties actually only require that these Indian tribes have access to a certain portion, a fair portion of the harvestable salmon in these streams and rivers, but not that Washington has to take any affirmative steps to protect the habitat or make sure that the amount of salmon in these rivers is large enough. The United States, which is on the side of the Indian tribes, says that no, the treaty assumes the existence of a sufficient quantity of harvestable fish, and that when Washington itself has taken actions that have degraded the habitat and reduced the amount of fish by, for example, creating a state road with a culvert that doesn't allow fish to pass through, then it is obligated under the treaty to remedy that. So that's just an interesting case of about Indian treaty rights and how they should be interpreted when they're dealing with an issue that didn't exist at the time the treaty was negotiated. 60 odd years ago. So the next case is called Pereira v. Sessions. This is an immigration case, and it's about a provision of the immigration law known as the stop time rule. And let me back up a little. There's provisions of the immigration law that allow the Attorney General to cancel removal proceedings. So removal proceedings are the proceedings that determine whether someone is deportable and can be sent out of the United States. The Attorney General can cancel removal proceedings and allow someone to obtain a legal status. However, there are certain requirements in order for someone to be eligible for this, and it's generally seen as some pretty high bars in order for someone to qualify for cancellation of removal proceedings. But one of the criteria is that the person must have had a continuous presence in the United States for 10 years prior to being eligible for this. So if they've had less than 10 years, they're not eligible for this cancellation of removal proceedings. So the idea is that people that have been here for a very long time, it's a much greater burden to be removed from the country, and so there's going to be this opportunity for them, an escape hatch where they can get the cancellation of removal, but only if they've passed this 10-year threshold. So the question is, when you measure this 10 years, when does it end? Now, there's a provision that when the government, this is the Department of Homeland Security, when it sends someone a notice to appear, so there's a notice to appear for deportation hearings, to start the removal proceedings, when they receive that notice to appear, that stops the clock. So that's when they have to have already achieved that 10-year threshold before the notice of appear is sent. And the reason this was done was specifically to prevent immigrants from deliberately delaying their proceedings in order to gain more time for eligibility. So suppose you had an immigrant who had been here 8 years and receives a notice to appear, and then their strategy would be to potentially to do everything they could to possibly delay the proceedings for another, year and a half or 2 years until they cross that 10-year mark and are then potentially eligible for cancellation. In order to prevent that, once that notice is issued, that's time's up for achieving the 10-year eligibility requirement. The problem here is that DHS has a practice of sending out these notices, the notice to appear notices, without any date or time listed when the person is supposed to appear for these proceedings. The problem is the statute that defines these notices to appear, specifically lists the date and time as some of the required information that must be included in a notice to appear. According to DHS, this doesn't really matter. That's just a minor defect. But it still should stop the clock. It's clearly marked as a notice to appear. That's the intent. But the argument on the other side is that these, just following the definitions in the statute, these are not actually legitimate notices to appear under the statute. They just do not qualify as notices to appear because they don't contain the statutory information that must be included in a notice to appear. Therefore, nothing stops the clock. And the argument also is that the issue is that the DHS sometimes issues these notices to appear with no date or time, and then follows up later with deportation proceedings. But sometimes this is years later. Years may pass between this initial notice to appear and when they actually move ahead with those proceedings. And during those years that pass, a person might pass that 10-year threshold and be eligible, unless that earlier notice had stopped the clock. So the question here is, does that stop the clock? Is it enough? Is it not? The particular immigrant involved in this case arrived in the United States in the year 2000, was served with a notice in 2006 without a date. So that's one of these up in the air. He'd only been there 6 years or so at that point, but received one of these notices that may or may not be valid. In 2007, DHS followed up with a notice that did have a date. However, it was sent to the wrong address and never received by him. Therefore, that clearly doesn't count under the statute because he must have actually received the notice. It's timed by the receipt of the notice. So that was 2007. And it wasn't until 2013 that he was detained by DHS and they actually moved forward with his removal proceedings. So at that time, by 2013, he'd been here more than 10 years and was potentially eligible for cancellation of his removal proceedings. But if the 2006 notice that wasn't dated, or included no hearing date, if that counts to stop the clock, then he's out of luck and there's no possibility of cancellation. So that's the question: is it the letter of the law and the formal requirements? Is that going to carry the day, or is it enough that everybody knew that this was a notice of appearance because notice to appear because it was titled and that's what it said on the form? So we'll see what the court does with that. Almost done here. We'll run through the last couple cases. One case is called South Dakota v. Wayfair. Now, this is potentially a big case that will affect anyone who's involved in much internet purchasing. So there's a 1992 case called Quillcorp v. North Dakota, and that itself was based on an earlier 1967 case. But it was a case where the Supreme Court held that a state can't require a retailer that has no physical presence in the state to collect state sales tax. So if you have a retailer who's in state A and they're mailing products into state B, but they have no facilities in state B, then state B can't tell that retailer, you must collect the sales tax for us for when you're shipping things into our state. If they have a physical presence in the state, if they have a warehouse or distribution center or something of that nature in the state, then the state can require them to collect sales taxes, but otherwise they can't. Now, this case, it was a 1992 case, so this is still the era of mail order catalogs. This is pre any significant e-commerce, and basically, the issue is if the state can't get the retailer to collect that money, then their only method of collecting that sales tax is basically to go after their own residents to make them pay a use tax. And most states have those laws on the books. If you purchase things from out of state and didn't pay a sales tax on those purchases, in many states you're required to report that those purchases and pay the taxes on it to your state. But in practice, these are very rarely paid, and so states feel that they're losing a large amount of tax revenue to these sales. So again, this earlier case, the 1992 case, was before the e-commerce era, and the argument here is everything has changed since then. There's been an explosion of e-commerce. It's caused a huge hit on state tax revenues. It's had also a huge economic impact on brick and mortar stores who have to collect the sales tax and are placed at a competitive disadvantage to these out-of-state sellers who aren't collecting the sales tax. And another argument is that the complications of a vendor having to deal with collecting the state sales tax, there was a concern before if you just have some vendor in state A and they're shipping products to other states all across the country, it's a huge administrative burden if they have to somehow keep track of the different sales tax rates and the processes for collecting and submitting that sales tax in all of these different states. The argument is that now that's basically been made simple by technology. There are vendors who provide this for commerce websites as just a plug-in function that they handle for you. So it's simple and easy, so that burden doesn't exist anymore. And also there's been some movement, though it's only partial, movement toward simplification across states and between state and localities in order to streamline the process of collecting sales taxes. So a number of states have gotten on board to try and agree on standardized definitions of types of products and services that are taxed, and in order to kind of make it easier for the retailers that are serving many states to determine which products fall in which categories and may be subject to different sales taxes by different states. So the argument is that basically the Quill case, this 1992 case, it's out of date now. It didn't anticipate how the world would change, and it ought to be overruled and allow states to pass laws that require these companies to collect sales tax for them. So in this case, South Dakota passed a law directly requiring these out-of-state retailers to collect sales tax. They passed a law basically specifically to challenge this rule and to create a case so the court would have to take another look at whether this is legal or not. And a bunch of other states have done the same thing to one degree or another. And so this is something that's going to come to a head, was, destined to, hit the court again at some point, and now it will, and the court will have to decide. An interesting thing about this case is that the specific legal doctrine that the court based its ruling in 1992 on is something called the Dormant Commerce Clause. And this is a principle that, because commerce has ultimate authority over interstate commerce, when Congress has not acted in certain areas, the states should not be allowed to create their own rules that impede or get in the way of the free flow of commerce. But it's an area where Congress has the authority, unlike some areas of constitutional law where the court is setting down a rule and saying this is just barred flat out by the Constitution, and states may not do this or that. This is an area saying that the court had ruled that because Congress has left this open for free commerce, the states can't interfere with that. But if Congress were to step in, they could make whatever rules they wanted here, and Congress could step in and say, this is how we want sales tax collection to be done by the states and kind of lay down the rules of how that could go about. And so this is something, the court has to step in now and decide what is and is not allowed, but Congress could at any time fill that gap and set the rules here. So the next case, real quick, it's a very it's kind of a niche area. This is a case called Wisconsin Central v. United States, and it's a case under something called the Railroad Retirement Tax Act, and it just happens that for historical reasons dating back to the Great Depression, railroad employees, instead of the normal FICA taxes for Social Security that most businesses pay and withhold on behalf of their employees, railroads withhold money under a different statute called the Railroad Retirement Tax Act, or RRTA. Now, this tax, it functions very similarly to the FICA taxes, except it's worded somewhat differently and it has some slightly different provisions. And the issue here is it requires withholding a percentage of an employee's money remuneration. And the question here is, what about stock? When employees have stock options and they exercise those stock options and get stock in the company, does this count as money remuneration? And does the railroad have to withhold money and basically pay taxes on these stocks? The railroads brought a lawsuit against the United States for a refund of taxes they'd paid on these exercise stock options, saying that these are not actually money remunerations. They say that unlike the FICA taxes, the RRTA doesn't explicitly include all benefits. It's not written as broadly to cover all benefits or any other non-monetary payments that people receive, and so instead it just says money remuneration, and stocks are not money, therefore there should be no taxes. The government, on the other hand, says stocks are basically a cash equivalent. They're easily valued and converted to cash, and they should be treated like cash. And so, it's just it'll be a statutory interpretation issue that the court has to grapple with. And then final one, this is the last case. This is a case about criminal sentencing. This case is called Chavez Meza v. United States. And this is a case about the federal sentencing guidelines. Now, in the federal government, in the federal criminal justice system, there's something called the Sentencing Commission that puts together what's known as the federal sentencing guidelines. And these guidelines, many federal crimes have very, very broad statutory sentences. A crime may say that this crime should be punishable by, for example, 0 to 20 years in prison. It's a huge span, and the range of the difference between someone just getting probation versus 20 years in prison is enormous. So what there is this sentencing commission creates these sentencing guidelines that take into account a large number of factors. Many are specific to the particular crime, and some are depend on the criminal history of the defendant. And based on these factors, basically scores are developed, and a person can look up on a table based on the score they get for the crime and their criminal history, and find a range of years that is the recommended sentence that they should be given. Now, due to some cases around a decade ago, there's some cases about these sentencing guidelines. They used to be mandatory. Now these are just guidance. They're not binding on the courts, but they're highly influential. A judge that's sentencing a defendant is required to do the calculations and determine the recommended sentencing range, but then they don't have to follow that range. They can depart up or down from that. But that's always the starting point, since they're required to do the calculations and figure out what range the person would be in under the guidelines. So the question in this case is, what happens if there's a range range for a particular sentence is later lowered after someone has been sentenced? And here's the specific case. This Chavez Meza pleaded guilty to possession of meth with intent to distribute. And he was sentenced, the range in the sentencing guidelines which is based to a pretty heavy degree on the quantity of drugs that were possessed. But the guideline sentence was 135 to 168 months. Now, these sentences they're always listed in months, which may seem strange initially, but just to convert that out, it's roughly 11 to 14 years. Was the recommended sentence. The judge decided to sentence him to 135 months, which was the bottom of that range. It was 135 to 168. He got the lowest sentence in that range, 135 months, which is a little more than 11 years. Now, later, the Sentencing Commission passed an amendment to the guidelines where the range for this changed, where it was 135 to 168. It became 108 to 135 months. That was the new recommended sentence for this range. So that changes it from 11 to 14 years down to 9 to 11 years. Now, there's a provision when a recommended sentence is lowered, the defendant who is sentenced under the higher range can make a motion to the court asking to be resentenced proportionally to the new lower sentence. So this Chavez Meza asked to be resentenced given the change in the ranges. Now, so the new range was 108 to 135 months. He asked to be moved down to 108 months, the bottom of the new range, since he was before at the bottom of the old range. The judge instead reduced his sentence to 114 months. So he did get a break, but it's about 6 months longer than what he was hoping for, and 6 months longer than the bottom end of the sentence that he could have got under the new range. The issue here is that the judge, in reducing his sentence, gave no explanation. There was just a boilerplate on the form that the judge used that just said that the appropriate statutory factors had been considered, but there's no explanation of why the judge chose 114 months, why the judge didn't use the bottom of the sentencing range as he had in the earlier range. And so the challenge here is whether a judge can do that, whether a judge is required to explain why they did that in resentencing. Some courts have said that an explanation is needed in order to basically provide a check on the judge and allow an appellate court to be able to understand what's happening and review what's going on. On the other hand, the statutory provision that allows for these resentencing after changes to the guideline, it doesn't specifically require the judge to explain the resentencing, where the statutes that provide for an original sentencing do require an explanation from the judge. So given that that's not required here, the argument is that that's just not required, and the judge was free to resentence how he wanted, especially if it was within the guidelines range. So those are the cases. There's 11 cases in a wide range of different subject areas. Again, we'll learn more about them as they get briefed and we get closer to oral argument, but some interesting stuff to look forward to, some interesting arguments, hopefully, that will all be coming up in April.
And that brings us to the end of episode 20. As of this recording, the next scheduled live stream will be on Thursday, January 25th at 9 p.m. Eastern. We're broadcasting these live streams on a regular weekly basis, and at least for now, we'll be live on Thursday evenings at 9 p.m. Eastern Time. Or check the Counting to 5 YouTube channel to find the next scheduled live stream. If you join us during the broadcast, you can ask your own questions in the live chat, and I'll do my best to answer them on the air. Links to resources related to this episode can be found in the show notes at countingto5.com. That's TO and the number 5. You can leave comments and questions on the show notes post at countingto5.com, on the Counting to 5 Facebook page or YouTube channel, tweet at countingto5, or send an email to mike@countingto5.com. You can call and leave questions and comments on the Counting to 5 voicemail line at 774-226-8685. That's 774-2-COUNT-5. If you aren't already subscribing to Counting to 5, please subscribe now at iTunes, Stitcher, or wherever you find podcasts. If Counting to 5 isn't available in your podcast app, directory, or service, please let us know and we'll do what we can to get it listed. Thank you for listening. This has been Counting to 5.